two types. Public officers shall give to a rightful person certified copies of public documents on demand. Section 76. Certified copies may be produced in proof of the contents of the public documents. Section 77. Presumption as to documents. The court shall presume to be genuine every document purporting to be a certificate or certified copies which is admissible as evidence. Section 79. The court shall presume to be genuine every document admissible in England or Ireland without proof of the seal or stamp. Section 82. The court shall presume the genuineness of collection of law and reports of decisions produced under authority. Section 84. Any 30 years old document produced before the court from proper custody shall be presumed as genuine. Section 90. Any 5 years old electronic record produced before the court from any proper custody shall be considered as genuine. Section 90A. Production and effect of evidence. Burden of proof. Establish witness, examination of witnesses, improper admission and rejection of evidence. Now, burden of proof. When a person is bound to prove the existence of any fact, the burden of proof lies on that person. Section 101. Burden of proof as to particular fact lies on the person who wishes the court to believe in its existence. Section 103. Burden of proving a fact which is within the knowledge of any person is upon him. Section 106. Burden of proving that a person is alive who has not been heard of for 7 years is on the person who affirms he is alive. Section 108. But within 280 days after dissolution of valid marriage, if mother remained unmarried, is conclusive proof of legitimacy. Section 112. When a woman commits suicide within 7 years of her marriage, its abatement by her husband or his relatives is presumed. Section 113A. Estoppel. Once person caused another person to believe a thing to be true, he cannot deny that thing in any proceeding. Section 115. Witness. Any person is competent to testify if he is not of tender age or lunatic, etc. Section 118. Dumb witness. A witness who is unable to speak may give his evidence in other manner. Section 119. No judge or magistrate be compelled to answer any question as to his own conduct. 121. Section 121. Accomplice. An accomplice shall be a competent witness against an accused person. Section 133. No particular number of witnesses shall be required for the proof of any fact. Section 134. Examination of witnesses. Examination of a witness by the adverse party is called cross-examination. Section 137. Examination of witness subsequent to the cross-examination by the party is his re-examination. Section 137. Any question which the person is putting to get answer is a leading question. Section 141. A witness may be cross-examined as to previous statements made by him in writing. Section 145. The court to decide when questions shall be asked and when witness compelled to answer. Section 148. The court shall forbid any question which appears to insult or annoy. Section 152. The court may permit the person who calls the witness to put any question to him. Section 154. The credit of a witness may be impeached by the adverse party or with the consent of the court. Section 155. A witness summoned to produce a document shall bring it to the court. Section 162. The judge may ask any question in any form at any time. Section 165. Improper admission and rejection of evidence. Improper admission or rejection of evidence is not a ground of itself for a fresh new trial. Section 167. The Indian Evidence Act 1872, it shall come into force on the first day of September 1872. Court. Court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. Fact. Fact means and includes anything, state of things or relation of things capable of being perceived by the senses. Any mental condition of which any person is conscious. Illustrations. That there are certain objects arranged in a certain order in a certain place is a fact. That a man heard or saw something is a fact. That a man said certain words is a fact. That a man holds a certain opinion, has a certain intention, acts in good faith or fraudulently, or uses a particular word in a particular sense, or is or was at a specified time conscious of a particular sensation is a fact. That a man has a certain reputation is a fact. Relevant. One fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act relating to the relevancy of facts.